Good evening, everyone. A warm welcome to this important and insightful webinar on legal frameworks to combat cybercrime in India and beyond. This webinar is brought to you by Naksh Foundation under its flagship initiative, Project CyberShield. I am Akshita Rawat, and along with my co host Prakshal Jain, welcome you to this webinar. It's our honor to be a host for this session. Cybercrime, a term that evokes concern among individuals and organizations. According to the Indian Express report, cybercrime reporting surged by 24.4% between 2021 and 2022. These numbers reflect a harsh reality that demands urgent attention. With the rapid progress of technology, the necessity for effective legal measures to address online threats has become more critical than ever. Project CyberShield works in the direction of mitigating cybercrime by using information, knowledge, and awareness as a tool. Today, we are here to unravel the intricate web of cyber laws and understand how India is combating cybercrime through its legal frameworks. To discuss this topic in more detail, we have a very distinguished guest with us today, Dr. A. Nagaratna ma'am. However, due to unforeseen circumstances, our esteemed second guest speaker, Dr. Gagandeep Kaur ma'am, is unable to join us today. Nonetheless, we are very excited to continue with this session and look forward to a productive and engaging discussion. Participants, please remember that this session is being streamed live on YouTube, and for those who are unable to join via Google Meet, you can easily participate by following the YouTube link provided. Participants also know that it is mandatory for all of you to fill out the feedback form, which will be available 10 minutes before the end of the session in order to be eligible for the certificate of participation. Without wasting a moment, let's invite and welcome our guest speaker for today's session, Dr. E. Nagaratna ma'am. Ma'am is an associate professor of law at National Law School of India University, Bangalore. She is also co-director at Advanced Center on Research, Development and Training in Cyber Laws and Forensics. Ma'am's area of specialization includes criminal law, cyber laws, and commercial law. Before joining NLS in 2006 as an assistant professor of law, she taught from 2001 to 2006 at KLE Society's Law College, Bangalore. Moreover, she has been teaching legal research and methodology and IPR laws to the LLM distance education course, Kuvempu University, since 2002. She has published several articles and contributed several chapters to international and national journals and books. Her research work titled Patients' Right Under Consumer Law was published by the Karnataka Institute of Law and Parliamentary Affairs in 2009. She has presented various research papers at the international and national seminars, conferences, and workshops, and has attended national seminars as a resource person. She is a life member of the South Asian Society of Criminology and Victimology and also a member of the International Institute of Information Technology Laws, Bangalore. Without a further delay, I would like to hand over the mic to ma'am for her insights on the topic. Over to you, ma'am.
Thank you, Akshita. So it's my pleasure to be here and talking about an extremely important issue, cyber crimes and legal aspects of India. So since it's a very vast topic, so I'll just address this topic through three important issues. One, we'll look into the substantive law framework, the provisions under which cyber crimes are regulated in our country, and we'll also look into the procedural aspects. And at the end, we'll try to identify the challenges that are affecting implementation of this law. So, as we all understand, like, and as Akshita was also mentioning, there is an alarming increase in the number of cyber crimes committed or in the number of crimes committed by abusing cyber technology. So, hence, it's a concern for almost every country, and in India also, it is a concern because if you see the extent of loss this cybercrime is resulting in, especially if you see the offenses which are economic in nature, financial loss costs to the country is also huge. And in addition, the extent of harm it is causing to individuals, institutions is also of great concern. So serious concern. So that's the reason why it's essential to see the existing law framework and identify both the strengths of the existing law as well as the weakness of the existing law. As many of you know, uh, India, in fact, has recently come up with the new criminal laws, the BNS, Bharatiya Nyaya Sanhita, the new procedure law, Bharatiya Nagarik Suraksha Sanhita, the new evidence law, Bharatiya Sakshi Adhiniyam. Now, when I talk about cybercrime related law also includes criminal laws. That is basically IPC, which is now BNS. Since cybercrime can include any crime that is committed by using or abusing cyber technology such as communication device, computers, internet, etc. So it's so wide that it can also include a lot of conventional crimes that are getting committed with the use of technology such as forgery, fraud, online cheating, etc. So therefore, of course, one of the applicable law would be our IPC or BNS. Secondly, in the year 1998, the UN General Assembly passed a resolution mandating all member states to come up with a law through which we could promote, facilitate e-commerce and e-governance. And since India is also a member to the UN, we had to come up with the law to specially foster the usage of technology for commercial purposes. So therefore, based on the model law this UN had prepared through UNCITRAL. It's called UNCITRAL Model on E-commerce. So based on that model law, India also framed a law which came into existence from the year 2000. So that is nothing but Information Technology Act. Now, on one hand, you have your general conventional criminal law, which could also be extended to cyber law to the possible extent. On the other hand, we also came up with a specific law only to deal with the usage of cyber technology. I would say usage of cyber technology because in the year 2000, when we made the law, we were not very sure about the extent of abuse this technology can be made of. So our focus was more on promoting the usage of this technology, especially for e-commerce and e-governance. So you have this special law which came up in the year 2000, which is called Information Technology Act. As I just mentioned, it was more focusing on promoting and facilitating e-commerce and e-governance. Until 2008, we were not very sure that we wanted to even extend this law to cover all forms of cyber crimes. So, in the initial parent law, Information Technology Act of 2000, you just had few sections talking about cyber crimes, specifically about hacking. Otherwise, we were not very sure of tackling cybercrime because there was debate going on between two schools of thought. So there's one school of thought saying we have a very wider criminal law which can extend to cybercrime, so there's no need of a new law. There's another school of thought which is saying no, these are new forms of crimes, so you need new criminal law. So anyways, there were also people who were saying cyber terrorism, cyber warfare, they're all myth. So we were just debating this, and that's when the unfortunate incident of Mumbai terror attack happened in the year 2008. And I'm sure a lot of you know about this terror attack. There are a lot of series made, movies made on this. And you notice that the accused, Kasab and other co-assailants were using satellite phones. So this is one crime where lot of electronic gadgets were used, and that's when we realized that cybercrime is no more a myth. And the same year, we amended the Information Technology Act to widen the scope of the law and bring under its ambit various forms of cybercrimes. So today, what we apply is Information Technology Act of 2000, but which got amended largely in the year 2008. And the amended provisions today deals with various forms of cybercrimes. In fact, we can classify the provisions of IT Act into two parts in relation to the way it regulates these cyber wrongs. So there are certain sections through which you can regulate cyber crimes, but by imposing civil liability, and that includes broadly section 43, 43 capital A and 45. Now, 43 covers hacking, data theft, data destruction, internet time theft. So it's a very wide provision. So anyone who commits offenses like data theft, data destruction, for example, let's assume I delete a file of yours from a computer, or I delete photos from your mobile phone without your permission. So for all these, we can apply 43. It also covers unauthorized access, including hacking. It also covers various forms of malware attacks such as virus attack, ransomware attack, etc. So I personally feel that 43 is a very vast provision, and almost every form of cybercrime which affects data and cybersecurity can fall under 43. However, this is a civil liability imposing provision. So I will have to file a civil case and claim compensation. Then we have 43 capital A, which specifically covers sensitive personal information. So, a lot of people think, it's only with the DPDP Act, personal law has come into effect in India. Not so, because if you see 43 capital A, this is nothing but a provision through which we were protecting personal data, which is digitalized, of course. But there was one problem in this provision. This provision could only be extended to a corporate entity, because the word used in the provision is any corporate entity handling, storing, possessing, dealing with our sensitive personal information or sensitive personal data is supposed to take care of our data. If they're negligent, they don't take care of it, then there is a data leakage, they have to compensate. So this was 43, which is again a civil liability imposing provision. And then you have 45, which is considered as a residuary provision, in the sense, if there is a violation of any provision or any rule under the Act for which you do not have a separate section imposing any sort of liability. So any violation of any rule under cyber law and you don't have a separate section could be brought under 45. That is also a civil liability imposing provision. So most importantly, these three provisions, by way of imposing civil liability, regulates cyber wrongs, which can also include cyber crimes. Now coming to the provisions through which cyber crimes are regulated, you have again vast number of provisions, especially starting with section 65 going until section 85. Section 65 protects computer source codes. These are the languages through which you communicate with your computer in simple term. So basically this includes computer programs, list of programs based on which computer functions. If anyone manipulates, deletes, alters computer source code, section 65 applies. If anyone commits offenses such as hacking, data theft, which I was just mentioning with reference to 43, any offense covered under section 43, if is committed with dishonest or fraudulent intention. So if this mens rea is proved, I assume a lot of participants today are law students, you'll understand what is mens rea. So if any hacking is committed with a fraudulent or a deceitful intention, dishonest intention, it becomes a criminal offense. So whatever was civil offense is civil offense under 43 becomes criminal offense under 66, provided it is committed with mens rea, that is dishonest or fraudulent intention. So today, therefore, if I hack a person's computer, the person can immediately file a civil case under 43 against me. If at all I've hacked it with dishonest or fraudulent intention, he can also book a criminal case under 66. As I was mentioning, it's a very vast provision. Every kind of attack on cybersecurity or data security, data integrity can fall under this provision. So that is 66. And earlier we had 66A, which I'm again sure a lot of you have heard about. Now, this criminalized sending any message which was annoying in nature, abusive in nature, or which had insultful content, intimidating content, etc. But since this was too vast and had a lot of vague terms, like sending any message which can annoy a person, so what is annoyance? So it was a vague term. So a lot of arrests under this provision was happening across the country. I just write some post on a social media platform. If someone got annoyed, could book a criminal case against me. And most importantly, the problematic part of the provision was that it was a cognizable offense. And we all know in cognizable offense, police can arrest without a warrant. So this led to arrest of a lot of people, including a cartoonist in West Bengal for drawing the picture of a cartoon of a politician. Similarly, two girls in Mumbai who wrote a post after one girl wrote a post after death of a political leader, the other girl just liked it. So both of them were arrested. So like this, we had a lot of arrests happening under the provision, and that's when a PIL was filed before the Supreme Court. So here I'm referring to Shreya Singhal versus Union of India, challenging this provision. So court says this provision is against right to freedom of speech and expression, and that's when it got repealed. So in fact, recently the parliament through a new law called Jan Vishwas Act has legally repealed this provision. So Supreme Court of course struck it down saying it's unconstitutional, but you could see that this section continued to be there in all the Bail Acts, etc. So finally, Parliament has removed this section through Jan Vishwas Act. So that was 66A. 66B is more important and relevant, especially for youngsters like you. Now, suppose I want to buy a electronic gadget, and let's assume it's very expensive. What do we generally do? We may go and buy it from some online platform, right? Like some online platform. So maybe let's assume it's a mobile phone worth 80,000. I'm getting it for 30, 40,000 on some platform. You just go and buy. Now, what if the person who sold you the device has sold a stolen mobile phone or a stolen laptop? Now, here is the problem because 66 B says whoever receives or retains any stolen computer system, communication device, which means even mobile phone, can be booked under 66B. See, you don't steal, but you just retain it. So let's assume I have stolen a mobile phone and sell it to you or gift it to you. The one who's possessing can be booked under 66B. So therefore, my suggestion would be that whenever you're buying any electronic gadget, ensure that you buy it from the original owner. Otherwise, the burden will be on you to disprove that you had menstruation, which is very tough, and that is 66B. 66C is about stealing the identity of a person on the online platform. Stealing identity is nothing but identity theft. If I represent myself as you, for example, I create a fake profile of yours, right? I use your photo and create a fake profile, or I send an email or a message in your name to your friends and ask them money, whatever. So just stealing your identity is covered under 66C. And under 66D, after stealing your identity, if I cheat a person, like let's assume I send an email in your name to your friend and ask that friend to send some money, that friend believes me to be you and sends money. So that is called as cheating by personation, which is covered under 66D. So your phishing, wishing, all those offenses falls under 66C. Whenever you receive such messages or emails, if you respond and you get cheated, it is 66D. 66E covers voyeurism, but there is again a problem here. If you see the title of 66E, it says breach of privacy. Now, generally, we assume breach of privacy would mean breach of data privacy, right? But if you see the content of the section, it has nothing to do with data privacy. It has nothing to do with information privacy. So the nomenclature is little misleading. So it's a reason why certain cases FIRs are wrongly booked under this section. It's a case of information privacy, but there are FIRs booked under 66E, which is wrong because if you see 66E, it's actually about voyeurism. And generally, we say voyeurism is nothing but breach of bodily privacy, taking pictures of private parts of someone's body without his consent. Or maybe the picture is taken with consent, but it is shared without consent. So therefore, let's assume A and B are in a relationship. They take personal pictures, etc. They break up, and A shares these photos, of personal moments, etc. So those kind of things fall under 66E. Now, you may also know that IPC, that is BNS, also covers voyeurism. So you have two provisions for voyeurism, one in IPC or BNS, the other in IT Act. So what is the difference between the two? Now, IT Act provision is a gender neutral provision. Accused can be anyone, victim can be anyone. But under IPC, it said if a man commits an offense on women, you could use IPC. So it was gender specific. Accused had to be a man and victim had to be a woman. But now with BNS, we made a little alteration. It says whoever commits this offense on women. So accused is gender neutral. A man or a woman or a third gender, anyone can commit the offense, but victim should still be women. So it is even now partially gender specific. So therefore, 66E of IT Act is more wider than IPC or BNS because it is gender neutral provision. Then you have 66F, which is about cyber terrorism, but the provision is so vast that it can include any sort of cyber crime which is committed with the intention of creating terror in the minds of people, or any form of cybercrime which might affect security, sovereignty, integrity of the nation. Or this is also vast to include any attacks on critical infrastructure, for example, power grids, etc. Right? And critical infrastructure can also include machines that are used to provide essential services. Like, for example, I'm sure you've heard about AIMS hospitals getting subjected to cyber attack. Now, AIMS hospital computers are definitely the ones which can be legally considered as the ones used for providing essential services, essential to life because it's about health service. So those kind of cyber attacks, we can use section 66F, which is titled as cyber terrorism. But if you see the provision, it's wide enough even to include attacks on one country by another. So therefore, this will also cover cyber war. Then you have section 85, which says any cybercrime committed by any companies can also be liable. See, today we hear a lot about companies conducting espionage on another, like trying to spy on another. Now let's assume I apply for a tender, or I've prepared my file for a tender of a very good project from a government. The rival company can use hackers to hack into my system, know my details of the tender, right? So these kind of things are usually referred to as corporate espionage. So if a company is involved in committing any of cyber crimes, be it corporate espionage or malware or data stealing, whatever, companies can be booked under section 85. Apart from the company, any officer in charge of the company, like the manager, the director, etc., can also be booked under the same provision. So that is 85. Now there's another challenging issue. Now, what if third parties go and commit a crime on an internet platform? Now, let's assume I go on Facebook and publish something obscene about A. Now, E, this is the question is, am I only responsible for this offense? How about the liability of the Facebook? So here we have section 79, which says for the crime committed by the third parties on an internet platform, that internet platform, that is intermediary, is not liable provided they fulfill certain conditions. Now, what are those conditions? Firstly, that internet platform or the intermediary should not know about this crime. So that is absence of knowledge. Now, this doesn't mean that you can sleep over your duty and say, I didn't know what was happening, right? So, therefore, you should be careful. So, you should take due care and caution. You take due care and caution, and despite that, you didn't know what was happening, then you're not liable. So, therefore, intermediaries should prove that the offense was committed by a third party. Secondly, that is, they have not involved in committing the crime. For example, let's assume I publish something obscene, and the Facebook, as an example, I'm taking the social media platform also promotes that post. So if they're promoting, that means they're involving in the offense, like abetting, helping, etc. So then they won't get the immunity. So as long as they do not contribute to the crime and they do not know about this crime, and they've taken all due care and caution. For example, they have filters, they have antivirus, they have all due care and caution in place. Despite that, third parties have committed a crime, then the intermediary is not liable. Now the question is, what is due diligence? We have internet intermediary platforms guidelines, which have undergone a lot of amendments, 2018, 23, etc. If you see the intermediary guidelines, it very clearly says that what are the do's and don'ts of an internet platform. To give you examples, it says if third party has committed a crime, it is brought to your notice, they publish something illegal, immediately remove it. If there are grievances by users, address the grievance within reasonable time. If police is investigating a crime and they want information from you, share that information with them. Basically, intermediaries are expected to coordinate and cooperate with law enforcement agencies, especially if the law enforcement agency has approached them legally, not like illegal. I just call and say, Facebook, share this detail of your customer, because that would be violation of privacy. But if I've legally approached them, through an application, it's called law request, saying, look, this is the crime under investigation, which is with reference to FIR number so and so, and in the course of this investigation, we want to know IP address of so and so person who is your consumer, etc. From and let us know what IP address was used at this point of time, etc. They have to share, because this is something that is crucial for investigating a case. So, and then they also have an obligation to retain data in prescribed format. Like, let's assume the police approaches the Facebook and asks some details from Facebook, and they say, we don't have it, we've deleted it, we don't have storage capacity. They can't do that, because as per our intermediary guidelines, it's supposed to maintain prescribed data for a minimum period of 6 months. So, like this, intermediary guidelines has list of do's and don'ts. If you're following that, then you're not liable for the crimes committed by third parties. Otherwise, any crime committed by third party intermediary can also be charged. So this is about the important provisions from IT Act. There are others, but these are most popular and relevant and important provisions. Now we have, as I've been mentioning, it's a vast law, especially 43, 66, etc. It's so wide. then why we still not been able to get good number of convictions? If you see the number of cases getting filed, they're huge. They're increasing every year, multifold. And when it comes to cybercrime, there's a unique feature you can notice. One, this is one crime which is increasing a lot in terms of number, quantity. It's also multiplying in forms. The form of crime you're not heard few years back, you're hearing. Example, deepfake. We didn't hear about crimes committed by deepfake a few years back, right? Or crimes committed by robots, etc. So these are not just about hacking anymore. It's about new versions of cybercrime. So one, it is increasing in number as well as it is multiplying in terms of forms of cybercrimes. So number of cases getting registered also huge, but if you see number of convictions are very less. So where are we failing? Of course, there are many reasons why we've not been able to tackle cybercrime, especially in terms of convictions. That's also because the procedure that is conducted in the course of investigation, inquiry, and trial is too complicated, and we're following the same procedure that you follow to investigate a murder case. The same procedure is expected to be followed when you're investigating a cybercrime case. For example, in a murder case, you have burden of proof, which is on the prosecution. You have to discharge it beyond reasonable doubt, and you have to collect all the evidences, very carefully by following procedural rules. Any non-compliance of procedural rules, the evidence might lose its evidentiary value. So, therefore, the procedure that is expected is very rigid. It was much more rigid under CRPC. With at least BNSS, there are some flexibilities. For example, see, we all know for registering FIR, police station jurisdiction was mandatory under CRPC. Only in some cases, they're saying like sexual offenses, etc. They're saying file a zero FIR, meaning you don't have to insist for jurisdiction. So for cybercrime also, it was essential that you had jurisdiction. But at least now BNSS, Bharatiya Nagarik Suraksha Sanhita says, you can even file an FIR without numbering. So zero FIR can now be filed for any crime, including cybercrime. Secondly, the new provision in BNSS says that you file the FIR without insisting for jurisdiction. Plus, you can also file EFIR. Now, let's assume I am from Bangalore, I'm traveling in Delhi, I become a victim of cybercrime and to come back to Bangalore and file a case. So the time would, I would be wasting a lot of time, right? And in cybercrime, time is the essence. It's like your medical emergency case. So all this golden hours, if is lost, so the remedy can't be provided, especially if it is a case of financial loss. The sooner I initiate the legal process, larger is the possibility of getting back my money. If someone has unauthorizedly transferred my money, if I'm running between police stations, etc., then I would lose that money because by then that person may withdraw the money from ATM or shift it to some other accounts. More accounts it passes on, more challenging it is for the police to investigate. So at least the new law says EFIR can be filed. Of course, a few years back, the Minister of Home Affairs came with an online portal. If you Google, you'll come across I4C. Right? So if you go through MHA, you have a I4C portal. There also, I could go and file a cybercrime case. Uh, but then the whole challenge is the case goes to I4C. They have to send it back to your own local police. Right? So this is also consuming time. So at least now you have online, FIR that CRPC in its new version BNSS allows. Then earlier, like if you had to record the statement of a witness, you would call that witness to the police station, take his statement and all. But today, BNSS says, okay, you can do even online recording of witness statements. So that is another advantage. See, here we're talking about crimes that are committed on the online platform. Within a span of seconds, I click crime is committed, right? But for police, it was time-consuming process, procure the attendance of witness. So I've personally seen cases where the accused is in Bangalore, case is under investigation in Bangalore. The witness is in Hyderabad. He's refusing to come to police station in Bangalore. Once, of course, police paid, his flight charges, got him to Bangalore, recorded his statement. Second time, police didn't have budget and he was not ready to spend on his own income. So today, at least law allows online recording of witness statements. So of course, there are some solutions we have found through BNSS, but still there are a few more problems associated with investigation procedure of cybercrime. So one such problem is all the offences under IT Act largely are cognizable, which means police should investigate. So in the course of investigation, they can arrest the accused. But most of the offences under IT Act are bailable. In the sense, I arrest, and as law students, you'll know, in a bailable offence, immediately you should release him on bail. So I'm not getting time to interrogate the accused, because see, these are not like your conventional crimes. I might have hidden incriminating evidence in form of data in some server. I might have encrypted the evidences, right? So if police have some time, they can extract, more information which are helpful for investigation. Of course, I'm not talking about the abuse of power by police, but genuinely, if I'm investigating and I don't get the remand of the accused, how will I investigate? So there is a mismatch. On one hand, you say offences are cognizable and empower the police as well as obligate the police to investigate. On the other hand, almost all the offences are bailable. I steal your data worth 1,000 also is bailable. I steal your data worth 20 crore is also bailable. So that is a problem. So there is mismatch between the nature of offences and the way law is treating. So that is one problem. Similarly, of course, most importantly, you can register FIR wherever you are, but actual investigation jurisdiction is still the challenge. Crime is committed in by, like, let's assume accused is in Delhi, victim is in Bangalore, the computer is used is in Chennai. You have three places which are places of jurisdiction. Theoretically we say okay, jurisdiction is no more an issue, but practically I have to go collect the evidence from Bangalore or Chennai. So there is definitely this whole problem of jurisdiction within India, and you can imagine the extent of problem you have beyond India. You want some evidence from abroad, there are much more challenges. One, the country with which you want the evidence, and we all know as Indians we are heavily relying upon foreign based internet services or related services, be it internet services, for example, Gmail, email, Rediff mail, they're all not Indian companies, right? So secondly, you think of any social media platform, again, they're not Indian based, like Facebook, Twitter, yeah, and any social media except Ku, I think few, most of them are foreign based companies. So one is, of course, you have to collect the evidence from intermediary. Now, what if that intermediary is storing your data in another country? So the evidence is in another land. How do you go and get the evidence from there? Right? So let's assume if there is an evidence in Bangalore, I'm investigating a case in Bangalore, I can go conduct search and seizure. I can go to the place where the server is, seize the data, of course, with warrant or whatever. But if it is in America or if it is in Australia, it's a challenge. Now, lot of social media platforms that are popular in India store data outside the country. Now we've started insisting last few years that no, you have to give us access to that data. You have to have a server here, but a long way to go. So whole problem is about jurisdiction and the country with which you expect coordination in terms of collecting evidence. You're supposed to have some bilateral agreements being signed, some multilateral agreements being signed, like we call it as MLAT agreements, Mutual Legal Assistance Treaty. So if you see the CBI website or MHA website, we've signed MLAT agreements with around 58, not more than 60 countries. Now, how about the rest? So if a crime is committed, let's assume from a country based in South Africa, and you want some evidence from there, that country may not cooperate with you because you don't have MLAT with them. And sometimes, it's not just MLAT, some bilateral agreement at least, but many countries have not signed bilateral agreements. Now, especially the harsh realities for us, larger threat is from our neighboring countries like China and Pakistan, and we don't have any mutual agreements with them, right? So all this hacking that happens, between these countries upon us, or between us and them, we can't mutually help each other. And you've been definitely also seeing how difficult it is to extradite accused from abroad. Like Vijay Mallya case, if you see, we've been trying from years to extradite the accused. So it's not just about collecting evidence from abroad; it's also about getting accused extradited from abroad if he's not in our country. So there are practical difficulties in actually implementing the law. So what I would want to say is, we have this vast law. Substantive provisions are wonderful, but procedural provisions, they're still complicated, right? So that's the issue with CRPC, and evidence law further complicates it. You have some expectations that are framed in form of rules in evidence law. For example, if I'm extracting an evidence, let's assume from this device. So this is my mobile phone. All the evidence is in this. If you give this mobile phone to the court, okay, it will be treated as primary evidence. But if you're for some reason unable to take this phone and give it to the court, see, at least this is phone. You can seize and give it to court. What if it is a server? So if the machine is the one you can't shift, or if the server is in another country, you can't bring it to India. or the mobile phone belongs to the accused and you don't know where he escaped, you've not been able to seize. So in these kind of cases, if you're extracting the evidence from it, you have to give a certificate called 65B certificate. Because under Indian Evidence Act 65B, Section 65B said you should give a certificate. Who should give the certificate? The owner of the device or a person in charge of the device. Now, why do you think accused will give a certificate saying this evidence is from my device and all that? So, a lot of cases you were not able to get this certificate is the reason that you had the evidence but you couldn't use it. So that is another problem, and we were expecting BSA, Bharatiya Sakshi Adhiniyam, would resolve this. Partially, they've addressed this, but not completely. So even now, in fact, certificate is mandatory. Lot of cases you don't get the certificate, especially let's say you got some data from a server based in US. Okay, because the data itself is so tough after that MLAT process, mutual legal assistance treaty, etc. Getting evidence is difficult. You've got it in form of an extracted data. If you've not sent the certificate, you can't use it. So that is where we're getting stuck. Hopefully, further laws or further changes to the law should address this. This is not just a problem which we faced in India. This is also a problem faced in many other Western countries. But they've amended the law in the sense in the place of certificate, they have alternatives. So the hope is that we'll address this through probably for future amendments. But as on today, it's a difficult task. Apart from this, see if it's a crime which is conventional in nature, you can see, you can pursue the evidence. For example, murder, any other offences, you can see the evidence. They are in form of knife, blood sample, fingerprints, right? But when we talk about cybercrime, we're talking about evidences that a layman cannot understand, data, metadata, right? So these are the evidences, which can't be even understandable by a layman. And we're expecting police to handle these kind of evidences. Of course, a lot of training is happening in our country since 2000, because that's when the law has come into effect. But it's an ongoing process. So continuous training is necessary on as to how do you extract evidence. What if I've deleted the evidence? How do you retrieve the deleted evidence? Of course, we have a lot of forensic tools, but I'm talking about India, which is so vast. And India has even now some of the police stations in rural areas, etc., forest region, remotely connected. And the infrastructure is a problem there. And we are expecting the police from all those regions to know what cyber forensics is, to use it, etc. So practically, it's a very, very challenging task. And upon this, law also complicates. Most of the cyber crimes are compoundable in nature. Compoundable in the sense, accused and the complainant or the victim can settle the matter. Now, with great difficulty, let's assume I, as a police officer, have investigated a case. I find out that A is the accused. You are the complainant, and if you know A is your friend or your employee or anyone, you will settle the matter. Then what happens to my case? All my efforts of investigation. So, except cyber crimes against women, children, and national security, etc., all other offenses are made compoundable. Now, if that was the case, you could have made non-cognizable, right? Certain offenses, of course, in the IPC were also compoundable, but they were not so serious that they usually would not get investigated because they were non-cognizable. Now, here, cybercrime, you make it cognizable, you involve the police, but you make it bailable and you make it compoundable. So the way we're treating cybercrimes is definitely not the appropriate way. And again, on those lines, we need to rework. So briefly, of course, these are the legal aspects that are indicators of both strength and weakness we have in our law. Otherwise, there are many more. Positive of time, I'll stop here and I'll be happy to take questions if you have.
Thank you, ma'am, for such an informative session. It's now time for the Q&A part of our session. Participants, please drop your questions in the chat box. So let me start with the Q&A part. So one of an attendee, Avik Bhattacharya, asking about the digital arrest and crime. So,
Right.
ma'am,
Okay. So it's a very good question. I should have taken it as an example to talk about forms of cybercrimes. Very timely, apt topic that we should all know. So I'm sure you have an idea about digital arrest. So usually in this case, uh, see. before, maybe I would have disclosed my details somewhere. Maybe the possibility, not in every case, but I'll give you an example of one such attempt which was done with relation to one of my friend. So initially, she gets a call from some unknown number. When she picks, they say we are from DOT, Department of Telecommunication. We have to update your telephone connection, something number and all. So you have to share your Aadhaar number. Now she believes it's a genuine call because it says you have to press one, two. So you think it's genuine. So she, presses that one. Then they say, okay, upload your, give your Aadhaar card number. So she shared this Aadhaar number. Now, 15 days after that, she gets another call from some other number saying we are from customs. Your Aadhaar number was used to purchase some drugs. So therefore, you have to immediately pay some, money as penalty. Otherwise, you can be arrested. And that's when she calls. And I said, first mistake you did was sharing Aadhaar without ascertaining who the other person was. So, anyways, the second part is what is called as digital arrest. While the first one is a case of phishing, wishing, right? It's also called as social engineering method. I make you believe that I am a genuine person and ask you to reveal some details like a PIN number, passwords, etc., or Aadhaar card in this case. Other card details in this case. So that is phishing. And second time when they say you've committed this offense, we're going to arrest you, etc., they make the victim believe that this person is under arrest. So in some cases, they've said you're already in arrest. If you go out, you'll be taken into custody. So be in that particular room, lock yourself, and from here you have to make online payments. In one case, in fact, the victim was even allowed to go out of the house because the victim said I can only make RTGS payment, for which she had to go to the bank, and they say, okay, don't tell about this to anyone, it's about your reputation, etc., but go and make the payment to RTGS. She goes to the bank and pays huge amount in lakhs through RTGS. And she was one of the employee of a court administration, unfortunately. So this is nothing but digital arrest, where they make a person believe that he has done something which is illegal, and make that person pay, some money, saying that if you pay this money, we will not book your son or book your daughter or book you. And in fact, in one case, a mother also died because of heart attack. So these kind of things. So in some cases, say your son is involved in a gang rape case, but he seems to be innocent, but we'll not name him in the FIR, so you have to pay. Or in some cases, I've even seen the worst form saying your son has met with an accident, we have to take him to the hospital. If you pay money, we'll take him to hospital. That's not about the arrest, but online frauds. So I think we should be very careful if any such phone call comes, even referring to the name of someone we love. It is always better to call back that person and cross check. So this is digital arrest. It became so huge a concern for us that our honorable Prime Minister had to also talk about this in Man Ki Baat. So, but despite that, there is increase in this offense, and as I think law students or otherwise also youth citizens, we should spread awareness about these kind of issues amongst our known ones. So that is digital arrest, for which you don't have any section in IT Act. Maximum is, let's assume that first part of the offense where I ask you to share your phone number, that can come under IT Act, like identity theft or phishing. But threatening someone, etc., can only fall under IPC, like extortion, etc. So it will be treated as a conventional crime as on today.
Thank you, ma'am. Now, next attendee I want to ask, is there any provision for the non-compliance by the cybercrime authorities?
So I couldn't get the question properly. So when we talk about cybercrime authorities, it can include many. Let's assume maybe it's the police, like not registering FIR. I'll assume that as a question. If you can clarify, it's fine. So if they are not registering FIR, they're not investigating. Of course, you have IPC provisions. Public servant not discharging his duty. So that is one possibility. Um, Otherwise, cybercrime authorities can also include. Yeah, I think it's just the police. So otherwise, you have digital signature issuing authority, but non-compliance with by them, I've not come across any such scenario. Yeah, maybe I can think of another scenario. Now, let's assume I am an officer who is in charge under the law to access your data. Okay, so I'll access your data maybe because I'm the investigating police officer or I'm the data controller, anyone. So I've got access to your data in the course of discharging my duty. So I should not reveal it to someone I'm not concerned. For example, I'm a police officer and I confiscate your phone in the course of investigating a case. That phone has some evidence. I should only collect that and give it to the court. But instead of that, what if I reveal it to the media? right? So then it is breach of privacy, and I can be booked under section 72. So 72 of ITAC talks about breach of privacy and confidentiality by the person who's authorized under the act. So that is another example of cybercrime authorities.
Another attendee, Vansh Bharti, want to know, are Indian laws developed enough to cover the current cases of cybercrimes?
Um, I can say largely yes. Why? Because as I was mentioning, 66, which is nothing but a replica of 43. 43 civil liability, 66 is criminal liability. So one reason I say yes, we can cover almost every form of cybercrime. One, because this is so vast. If you see, it has a lot of clauses until J, I think A, B, C, D, F, G, H, I, J. So, like, you have one of the clause which says that if I do anything with which the value of the information you have on your computer is lost, so I do something with which the value of the information is lost. So value of the information in the sense, it's so vast a word. Like, let's assume you're entering your PIN number in an ATM, no, machine. So I just peep and see your PIN number. So the PIN number's value is lost. So that is an example of a wider provision you have under 66. So similarly, it says any malware attack. So you may call it as I said, ransomware attack, salami attack, the technical terms through which malware attack is known. You call it as anything in your technical language, but under law, it is an offense which falls under 43 and 66. So if you see 66 or 43, substantive offenses related provision is very vast. Second reason why I say it's a very vast law is because if you see the definition of terms like computer, computer system, computer network, computer resource, they're so wide that it can include any versions of computer, not just desktop, laptop. And I'm sure, as I express, there are many other gadgets which can be treated as computer today, of course, including your smartwatch, your smartphone, pacemakers, or AI based tools, or IoTs in the sense your home appliances that work either based on software program or that are connected with internet. IoTs are devices connected with the internet. For example, through my phone, if I can access my refrigerator on it, or access my washing machine, access my car, all these, if you see, it falls under the legal definition of computer or computer system or computer network. So therefore, you may hear people saying AI based offenses can't be covered. Of course, some extent there is a problem, but let's say I am misusing an AI based tool. It can be easily brought under the definition of any of these terms and be dealt with under IT Act. So we don't have a problem when it comes to substantive law, according to me. Procedural law, as I said, there are issues. How you collect evidence, how you present the evidence before the court, definitely is a problem. But otherwise, substantive law in its current format can be used against any form of cybercrime. Um, but yeah, the whole problem is in the way you implement it.
Another attendee, Advocate Sabina, want to ask, how are technological advancements such as AI and blockchain being leveraged to combat cybercrimes in India?
Okay, a good question. See, one is especially about AI. Of course, today law enforcement agencies have started using AI-based tools to regulate crime, prevent crime. Best example is today you have a lot of cameras in the traffic signals which are AI-based also. So based on the speed at which you are riding your vehicle, they can know if you're violating traffic signals. Especially in Karnataka, we've installed it off recently like that. So that is an example of AI-based tool used to prevent traffic-related crimes. Similarly, facial recognition systems, etc., can be used in huge crowd gathering, like let's assume, Kumbh Mela, etc. So those kind of places, AI-based cameras are helpful. Facial recognition, systems based devices are helpful. So to prevent the crime, also they've been useful. Or another example, using drones to administer prisons, because in the entire huge prison, if you can just use drone for surveillance of prison, so this can be of course used for regulation of crime or for maintenance of law and order. Similarly, blockchains also in India we've not been using, but other countries, for example, while collecting digital forensics, the evidence by use by using digital forensics. The whole question is, how do you maintain the integrity of the data? Like, I have collected the evidence, but what if that evidence is tampered? Because when you talk about cybercrime, the evidences are in form of data, mobile phone. What if it is tampered? Now I will genuinely, let's assume I have an IO, I will genuinely handle that device for just seeing whether there is an evidence in it or not. So technically it becomes tampering. If you use blockchains, you can ensure that from one end to another end, it is not tampered. So there are various ways through which you can use blockchain technology to ensure that the data integrity is maintained, so that evidence requires admissibility. But in India, we've still started, we've still not started using this. Why? Because one reason is blockchain would mean multiple people, uh, working in network. Now, these multiple people can be private entities also. So that's the reason why, as of now, government is not using blockchain. But I'm sure in future we will start using it for crime regulation also.
Ma'am, I want to ask, can we take more questions or not?
Yeah, we can take sure. Maybe another two, three.
Okay, so another attendee, Rohini Krishna, want to ask how effective are the current regulation in combating cross-border cybercrimes?
Yeah, and I gave a very brief indication when I was talking about jurisdiction. It's very bad, especially for a country like India, which is based in South Asian region. It's very bad, because if you see the Western world, so you have European Union Convention only to combat cybercrime. It's called Budapest Convention. So though it is European Union Convention, America is also party to it. So in the Western country, at least you have this convention which requires, mandates, obligates, empowers countries to help each other. So if there is a crime that they investigate in one country and the other country suppose has evidence, they'll share. Not just about sharing evidence, even information. So let's assume there is a malware attack. So one of the computer from one region. So some of the computers in a region is subjected to ransomware attack, and that malware is spreading from one computer to another computer, reaching other countries. They send alerts. So even there is timely sharing of information and not just evidence, especially if it is about cyber terrorism and child pornography. They have a very strong network of network system to ensure that they help each other in blocking access to illegal contents, etc. Now, coming to India, India is not a party to Budapest Convention. Reasons are many, they're debatable, but very briefly, I can mention that India feels that we've not got enough bargaining power because we're not a party to the convention when they were drafting it. So at this stage, if we join, they will be able to collect our data, but we may not get access to their data. So it doesn't want to be a party. So we don't, therefore, we're not a party to Budapest Convention. As of now, last few years, UN is trying to come up with a convention. It's called UN Convention on Cybercrime, but it is under the drafting stage. India has also involved itself in the drafting process. Once that comes into picture, maybe you may have some law where you'll have international collaboration. So as of now, you don't have an international collaboration. As I was mentioning, between countries, we have signed MLAT agreements only with around 60 countries. Last research I had seen it was 58, but if you now see the website, you know the accurate number. Apart from this, the other countries we don't have MLAT, so you don't get to collect the evidence from them. Even if you have agreement, there are other hurdles. For example, a crime in India may not be a crime in another country. For example, uploading porn material, obscene material, is a crime in India. It's not so in another country. So if you're collecting evidence from another country, they may refuse, saying that this is not a crime in our country. So like this, there are hurdles. So internationally, it's very tough. And why I said being in South Asian region, it's more tough for us because we've been relying a lot on the internet services of the Western countries companies. Like as I was mentioning earlier, you name it, they're all foreign based, be it social media platform, Gmail platform, or search engines, Google search engine, etc. So we are using it, and our data is going to some other country. So and none of this is stored in India. This, except for some servers that are located in Singapore, all the servers of these internet platforms are located outside South Asia. So every country in South Asia has this challenge, not just India. But since India is like a big IT hub, we have a lot of IT cities, etc. We are into data processing. We have huge number of internet users, right? So the digital divide is coming down, but problem is more usage would mean more exposure to risk and lesser extent of coordination. So therefore, internationally, there is hardly anything that as of now is helpful to us. But I'm not saying it's completely a bad scenario. Last few years, we've been signing at least bilateral agreements. For example, whichever country our prime minister goes, I've seen like whenever he signs a mutual agreements, like bilateral agreements, they will have a clause talking about ensuring cybersecurity. Very recently, we've signed such an agreement with Germany also. A few years back with America. So bilateral agreements, we're trying to do it with many countries, Switzerland, etc. Then when it comes to some regions, because of the neighbors, we have differences of opinion. It's very tough. SARC level, you can't, right? ASEAN level, you can't because Pakistan, China, India can never come to a unilateral conclusion. So signing something at the regional level is also tough. Like European level, you have a convention, but our level, because of the tensions we have between the countries, it's very hard to come up with some regional level conventions. So this is in brief the scenario.
Another attendee, Shraddha, want to know what is Daniel of service attack.
Yeah. Uh, okay, so these are technical terms we use to refer to various forms of cybercrimes. Now, this is called as DOS attack, denial of service attack. Now, in this case, what I do, I will send a huge number of requests to your server, your website, your server, your computer. I've seen so many, like I'll just compare it with just drawing an analogy. Let's assume you had an old, model of mobile phone. If I was sending many messages, what would happen? Your inbox would be full and you wouldn't get, you know, new messages, right? So you would lose genuine messages. Now, similarly here, the attacker is sending so many requests to this website or this computer that it is unable to handle the genuine, requests. And the genuine user can't use the website. Okay, so this is called DOS attack. Usually, it is said that terrorists use this mode to attack government-based websites and platforms. Uh, this can also be committed at a time from multiple computers. If it's one computer and I'm sending requests to your computer, it's DOS. If it's from multiple computer that I'm sending requests to a government website, it's called distributed denial of service attack, DDoS attack. Let's assume another example. Today, 9 p.m. is the last deadline for you to submit an application for a government job, and the ministry says you should apply only on my website. Today, 9 p.m., you genuinely want to apply for this application, but the attacker has sent all these DOS kind of requests that a genuine applicant could not submit on time. Right? So this is an example of DOS attack.
Ma'am, the next question is raised by the Sanjeev Chauhan and want to ask how investigative agencies preserve electronic evidence.
Very tough question because practically, one, we don't have SOP, standard operating procedure, which is applied across the country, which says how you collect, how you retain, etc. So this was in fact the challenge. Few years back, the Supreme Court uh, constituted a committee, and that committee also has Supreme Court judges, and they wanted to come up with some rules relating to retention of evidence, who should retain, how you retain, etc. And luckily, I was also a part of this discussion, which happened at South Indian level. So, we identified the challenges. So, let's assume, you have some evidence on a CD and you have to retain it for you. And, in our country, to file a case and to complete a trial, it takes years. The burden is, as of now, on the complainant to provide all the evidence. So, you're the complainant and you have to keep that CD in a working condition until that case is disposed of, and you never know when trial completes, when appeal completes. So let's assume after 2 years the court opens your CD, it is cracked. So so I'm just giving a simple example indicating how difficult it is to store evidence, retain evidence, that to retain evidence in an unalterable format. For example, if I've seized your computer today, in the seizure memo, I'll write today's date as 25th January, date of seizure. Okay. I take your computer to the police station and I open the computer only to see whether there's an evidence or not because I'm curious, right? Ideally, I should not do it. Actually, I should send your laptop to the forensic lab because they will forensically open and see. But in some cases, unknown or whatever, unaware, so police have opened the system, Okay, and then they found incriminating evidence. It's a serious case. You found all the evidence. You think you've cracked the case. You're happy that, okay, you investigated the case, you've got every evidence. But when you submit this to the court, what happens? Last access date would be tomorrow because you seized it on 25th, but you opened it on 26th. So these are the mistakes that are generally happening. But to avoid this, we today have, of course, SOP, standard operating procedure, which talks about how you should extract evidence, how you should retain, etc. How do you store? There's not much that has been done. And the committee I was mentioning about, the Supreme Court Constituted Committee, they were also saying, no, 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 we can't take the responsibility of keeping the evidence in the court because these are digital evidences. They are like in form of data, metadata, CD, pen drive, floppies few years back. And maybe tomorrow, pen drive can also get replaced with something else. Today itself, you see pen drives in different shapes, sizes, right? So you don't know when what will change and how do you retain is also a challenge. So it's very tough practically, but legally, the burden is on the party who's filing a case. If you're a complainant, if you're a prosecution, you have to store it. That to store it in a manner where it doesn't get deleted, doesn't get altered, doesn't get accessed illegally, etc. It's a challenge. And yeah, let's see how we further progress upon this, maybe through new guidelines or technical safeguards or measures.
Thank you, ma'am. Can we sum up this session?
Yeah.
Thank you, ma'am, for such an enlightening session. Your insights into the legal frameworks to combat cybercrime were truly eye opening. This brings us to the end of today's webinar. A heartfelt thank you to our esteemed speaker, Dr. A. Nagaratna ma'am, for sharing her expertise and helping us understand the legal frameworks to combat cybercrime in India and beyond. I'd also like to thank all of the participants for joining us today. Remember, awareness and vigilance are our strongest defenses against cybercrime and threats in today's world. Stay connected with Naksh Foundation and Project CyberShield for more initiatives like this. Have a wonderful evening and stay safe online.
Thank you.
Thank you, ma'am.
Thank you, ma'am.
Participants, we kindly request you to fill the feedback form, which has been mentioned in the chat box. Participants, we would like to inform you that we have a webinar planned on how to file cybercrime cases on 8th of February and we request for your presence.
Not working now.
Participants, kindly wait for a few more minutes. We are resolving the issue with the feedback form. Participants, kindly check if the feedback form is working now.